Chapter 15. The Commerce Clause. Article 1, Section 8 of the Constitution reads, Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. The Commerce Clause represents one of Congress's most important sources of legislative power. It vests extremely broad authority in Congress to act in a wide range of matters, even those that do not on their face implicate interstate commerce. For instance, Congress has relied upon the Commerce Clause to enact legislation on environmental protection, drug labeling, the minimum wage, and civil rights. The Supreme Court's interpretation of the Commerce Clause is complex and has evolved over time and continues to evolve. Based on the interpretation of the word commerce and the phrase among the several states, the Supreme Court has held that Congress has the power to regulate three categories of commercial activity. 1. The channels of interstate commerce. 2. The instrumentalities of interstate commerce. And 3. Any activity that has a substantial effect on interstate commerce. Let's discuss. First off, Congress may regulate the channels of interstate commerce. Channels are the places where commerce occurs, such as roads, rivers, airways, as well as the Internet. Second, Congress may regulate the instrumentalities of interstate commerce and persons or things in interstate commerce. This category includes anything that is used to carry out commerce or anything that moves in interstate commerce. For instance, vehicles, boats, airplanes, machines, as well as people. Third and lastly, Congress may regulate any activity that has a substantial effect on interstate commerce. This means that Congress can regulate any activity, even a local activity, as long as it substantially affects interstate commerce. In order to understand the full extent of Congress's commerce power and the types of activities that Congress may regulate under the Commerce Clause, we will look at the Supreme Court's Commerce Clause jurisprudence over time, which is generally divided into three different phases. From the earliest days of the nation to the 1930s, around the time of the Great Depression, the Supreme Court generally moved towards a more expansive interpretation of the Commerce Clause, recognizing the important role of the federal government in a developing nation of several states. After the Great Depression, then-President Franklin D. Roosevelt implemented a series of domestic programs known as the New Deal, which were aimed to restore the economy and to provide relief to the poor and unemployed. Although the Supreme Court initially struck down New Deal legislation since it sought to expand the power of the federal government, the New Deal marked a turn in Commerce Clause jurisprudence. From 1937 to 1995, the Supreme Court developed an extremely expansive view of the Commerce Clause. And during this period, no federal laws enacted under the Commerce Clause were struck down. The year 1995 marked another turn in Commerce Clause jurisprudence. In this year, for the first time in nearly 60 years, the Supreme Court, led by Chief Justice Rehnquist, struck down a federal law under the Commerce Clause. The Rehnquist court was concerned with the federal government's encroachment on the police powers of the states and cited the 10th Amendment to limit the reach of the commerce power. In this chapter, we discussed the Commerce Clause, which gives Congress the power to regulate commerce among the states. We learned that Congress has the power to regulate three broad categories of activity: the channels of interstate commerce, the instrumentalities of interstate commerce, and any activity that substantially affects interstate commerce. In the next chapter, we will begin to discuss landmark Supreme Court decisions that have interpreted the Commerce Clause.